All right, let's get analysis now. We're joined via Zoom by Melusi Xulu, Managing Director at Donda Attorneys. Thank you so much for your time this afternoon. Now, talk to us about the main principles of this judgment. I also want to touch on specifically, the Gauteng High Court finding that the former president instituted the private prosecution of Ramaphosa for an ulterior motive.
Good afternoon, Nati, and good afternoon to the viewers at home. Thank you for inviting me. I think let's start with the main issue, which is the nolle prosequi certificate. Now, if you go to Section 7 of the Criminal Procedure Act, it says if an aggrieved party wants to privately prosecute someone, they must get a nolle prosequi certificate from the Director of Public Prosecutions. Now, this nolle prosequi certificate that was used by the former president against President Ramaphosa was a nolle prosequi certificate that was issued in Durban, specifically in KZN, from the NPA, like that side of the country. And specifically, it was a nolle prosequi certificate in relation to the other parties and not the president. So I think that was the first important part of this judgment today, that nolle prosequi did not apply to the president.
And just talk to us about, just some of the reasons behind the ulterior motives that judgment entailed. I mean, talking about just the timing of, Mr. Zuma applying for this private prosecution.
Obviously, it's a political agenda that can be alleged at that part, because remember that in December there were going to be elections for the ANC presidency, and there is a set aside, or a step aside rather, rule in the ANC constitution that if you are charged with a criminal offense, you must step aside, as it has happened to the other members of the party, such as the former Treasurer General, which is Ace Mahashud. So one may think, although I'm not a political analyst, one may think that he might have been trying to, he could have been trying to have that rule to be applied to the president so that he cannot stand for the election. That may be a perception, that may be thought.
It was also noted, that Mr. Zuma's charge rested on the conduct and did not constitute a criminal offense. His attempt to then prosecute the president could not lead to a conviction, and this is something that the court found. Should Mr. Zuma have then taken another route, to institute, perhaps a commission of inquiry or something of that nature? I mean, what then is left of him to do?
Obviously, the case, as it was an application, did not deal much with the merits of the case, but the charge was accessory after the fact, which means the former president was saying that President Ramaphosa assisted the parties when his medical information was given to the public. So in a way, there's no way that could have been proven. I don't think there's any other platform that the former president can use, which leads us back to what we are talking about, that there could be a perception that he was trying to destabilize the presidency of President Ramaphosa when it came to the ANC election. But as for the case, there's no strong case for what he was trying to charge the current president with.
Let's talk about the next steps. In terms of this particular matter, the court did award costs, against Zuma. We know that last month it also awarded costs against Zuma in the private prosecution against advocate Billy Downer and journalist Karen Moore, again with costs. He hasn't indicated his next steps in relation to this particular case, but he has indicated, of course, that he will, be appealing the previous court ruling, that is.
He has indicated that, I think that the judgment was given in the 7th of June last month, as you say, but we're still waiting for that. Today is the 5th of July, so there has been no indication. In my view, there are so many other issues that he has, legal issues, such as the arms deal case that is currently continuing, maybe his legal team may advise him to focus on that because he has not won his other cases.
Mr. Xulu, just as we wrap this conversation, of course, the issue of the Nolly prosecute certificate, and the use thereof has come out significantly in several matters to date. Just talk to us about some of the fundamentals and the key lessons and learnings that we can take out of, these inferences and some of the gaps that we've seen in these cases.
Okay. The private prosecution is simple. It's simply where you've opened a case and the NPA or the prosecution decides that there isn't a sufficient case to stand for them to prosecute the accused. So the only avenue is to take the matter privately and ask for a private prosecution, and you must be given a nolle prosequi certificate specifically against that particular accused that you want to open the case against. So I think what we've learned is you should not use it for ulterior motives, and you should be certain of your case. We do not have many cases which are like this or of this nature. So we are learning every day about this particular private prosecution. But it's clear that when you're going to privately prosecute someone, you must be certain about your case. And most importantly, today, it was an obvious lesson. You must have that nolle prosequi certificate against the accused, because that's where the case started with regards to today's application judgment, that there was no nolle prosequi certificate. So that's where you start with your private prosecution.